Patients, their relatives, are not only questioning doctors about competency or correctness of the treatment or diagnostic methods, but moving a step ahead. Doctors are being sued very often for the event of unintentional medical errors by their patients. Such litigations land up the healthcare providers in severe financial losses. Considering various legal costs involved and huge claim amount towards compensation, having an indemnity insurance safeguards the professionals against financial liabilities for damages caused on account of unintentional errors and cost of defending oneself in the court of law. With this reference, our last session for the day is on the topic indemnity, the need of the hour for healthcare providers. And to enlighten us on the topic, we have with us Dr. Sanjay Gupte, sir. Besides having an excellent clinical practice in obstetrics and gynecology over the last 4 decades, Dr. Gupte has been a professor at BJ Medical College, Pune. Dr. Gupte is a well-known national and international academician with many chapters and publications to his credit. His dogmatism about standards of clinical practice within the framework of ethics has led him to acquire a degree in legal science and is now identified as a national consultant in medical legal issues in medical practice and has an experience of 37 years in this field. Sir has served as a past president of FOGSI, that is the Federation of Obstetrics and Gynecology Society of India, with nearly 37,000 members. Dr. Gupte is the director of Gupte Hospital, Pune, with state-of-the-art facilities for in vitro fertilization, micromanipulation, assisted hatching, cryopreservation, and the list goes on. I extend a warm welcome to Sir. We have with us Dr. Rajiv Yerodekar, sir. Sir, would you like to say a few words?
Of course. Good afternoon, sir.
Good afternoon.
It's an absolute delight and pleasure to have you. And well, Nabila has done the honors of introducing you, but I must acknowledge on this public platform that Sir and Mrs. Gupte both have been our teachers, and we have been totally mentored by them in our residency at the BJ Medical College in Sassoon Hospital. And Sir, as Nabila said, Sir and Madam have been excellent clinicians, very humane professionals, and thereafter professionally, since we started engaging with them through symbiosis, Sir has been guiding and mentoring the entire postgraduate diploma in medical legal systems, which we conceptualize under the mentorship of late Advocate Ram Jethmalani. Advocate Milind Salunke is also on this forum, and together we've tried to create an awareness about legal awareness amongst the medical fraternity. First, it started off with the Consumer Protection Act, the fears and the entire apprehensions which the medical fraternity had against the Consumer Protection Act, and every day, thanks to the litigation scene in India, aped from the West, we are adding newer dimensions to the postgraduate diploma in medical legal systems. And so thank you for being with us. I don't think so you missed out a single year of this national seminar, which we have conceptualized since 1999. And you recollect the 30th April was the first day in 1999 when we had invited late Dr. Banu Koyaji Madam and Advocate Ram Jethmalani to address our delegates in a small shamiana. I forgot, I could have shown that photograph for posterity's sake to rekindle memories of old. It's always a pleasure and a delight to have you, sir. Thank you so much.
Rajiv, thank you so much. And Nabila, you too, for a very good introduction. And Rajiv, I must not forget to mention that we have been fortunate always to see students of Zumdar sir, who actually taught us in Ferguson College, and that's when our relationship, the very close and family relationship with the Symbiosis Institute starts, years back, and that's why, I'm always delighted, happy, overwhelmed to be on the forum. And yes, I do remember that Shamiana and the first meeting we had in the Symbiosis campus on the SB Road. Right. Nabila, we had a wonderful talk by Professor Vijay Natarajan, a very inspiring talk, and he and his team has been doing wonderful work in the hospital. And after that nice talk, we have to come to some mundane talk now a little bit, but an essential one, and that is about the insurance. So I hope I'll be able to share my slides, and let's see if we can do that. Indemnity, as Dr. Nabila said, is the need of the hour for the healthcare providers. And so we need to know a little bit of the basics of this, what this indemnity and the insurance is all about. So what is the system of insurance? Insurance is a system that protects against the risk of individual loss by distributing, according to the law of averages, the burden of losses over a large number of individuals. Payment of the premium serves to contribute to the coverage fund and provide compensation for any members of the group who may suffer from a defined loss. There are numerous types of insurances, including life insurance, health and disability insurance, fire and casualty insurance, title insurance, and liability insurance. In medical practice, there are two main types of insurances that we need to know. One is the health insurance, and second, the indemnity insurance. Health insurance is a fairly modern construct and differs from other types of coverage in that it is an entirely voluntary system. And as in our country, many times it's kind of a part charitable system also, like, our Ayushman Bharat Yojana. A service benefit plan generally involves the payment of a premium and then the additional requirements of a deductible and co-payments. Generally, these policies directly reimburse the participating provider of health services within the limit of coverage. In the second type of insurance, which what we are going to discuss today, is the indemnity insurance, where the insureds are physicians and other healthcare providers. Overall, in medical practice, insurance is a contract in which, in lieu of consideration of a certain payment or premium paid by the insured physician, the insurance company agrees, in the case of an injury or harm caused by negligence, to pay to the aggrieved party a sum of money determined by the trial judge. So what are the basic elements of this indemnity insurance? The insurance contract is characterized by the following 5 basic elements: an insurable interest who is subject to loss, an insurer who assumes the risk of the defined loss, the use of a general scheme to indemnify this loss, and a group made up of substantial membership to contribute to the coverage fund, and each with their own insurable interest. So indemnity, the professional indemnity, is meant for professionals to cover a liability falling on them as a result of errors and omissions committed by them while rendering the professional service. The indemnity applies only to the claim arising out of bodily injury and or death of any patient caused by error, omission, or negligence in the professional service rendered or which should have been rendered by the insured or the assistants or the team of people employed by the insured. So it's important to know the meaning of the term indemnity. The term indemnity means to compensate or reimburse. The principle of indemnity is strictly followed in liability insurances. Indemnity means a legal obligation to cover the liability of another. To indemnify does not merely mean to reimburse in respect of money paid, but to save from loss in respect of the liability against which indemnity has been given. To indemnify means to make good a loss suffered by a person in consequence of the act or default of another. See, it's important to know these terminologies in detail, because otherwise we don't get the real feel of what this indemnity actually is. So indemnity is often used as synonym for compensation, but actually it is an indemnity is a compensation paid by A to B for a particular loss caused to B. The compensations in the form of cash, payment, repairs, replacement, and reinstatement. What is important is the indemnitor, that is A, may not be responsible for the loss suffered by the indemnity at all, that is B. In fact, it could be due to negligent action by the B himself, and still the payment is done to, the replacement or compensation is done by the A. So why indemnity is important? Doctors are also human beings, and to we know that to err is human. Medical error or injury has been known since the time of Hippocrates as principle of non-malfeasance, derived from the doctrine of primum nocere, which means first do no harm. And its natural corollary, benefits or do good, which means doing the right thing for the patient. So this is where the medical error and indemnity started long back. That means it is based on basic principle of bioethics of non-malfeasance and beneficence. With the modern advancement in the medical profession, the doctor-patient relationship has also changed from paternalism, where doctors were parent figures taking medical decisions on behalf of their patients, the current patient-centric, where the patient is an equal partner. When we started our practice, the family doctors were such that they not only took these medical decisions for the family, but even many times other social decisions also were handed over to the doctor. The things are considerably changed now. Of course, the type of patient has also changed from ignorant to being enlightened, and sometimes hyper enlightened due to the Google doctor. With the advent of Consumer Protection Act 1986 and various judgments by the Honorable Apex Court of the country and other courts and commissions, patients have started challenging the doctors and their treatment. Numerous cases are being filed against the doctors, hospitals, medical staff, etc. Under consumer law, criminal law, civil law, there are so many places, including even the Human Rights Act and the various like medical councils of states and of the country. So compensation in lakhs and crores of money is being awarded in favor of the patient or his or her relative, which is to be paid by the doctor from his own pocket. With increasing litigations against the doctors in the country, it has become very important and vital for the doctors to obtain insurance cover against all such litigations and compensation to be paid, if any. And later on, we'll be going through some of the examples why this has become almost life-saving for the doctor now to have these insurances. So accordingly, in the year 1991, the professional indemnity insurance was introduced for the doctors and hospitals in the country. So professional indemnity insurances are designed to provide the insured person protection against financial consequences of legal liability. The indemnity policy is meant for professionals to cover liability falling on them as a result of errors and omissions committed by them whilst rendering professional service. If the insured is legally liable to pay damages or compensation to others, the policy will indemnify him subject to the terms and conditions and limitations of the contract. And this is very important that we must remember there are always terms and conditions and limitations of the contract which we have to recognize. Indemnity is also available in respect of legal cost awarded against the insured as well as legal costs and expenses incurred by the insurance with the written consent of the insurers in the defense or settlement of the claims. So what is the importance of this professional indemnity to medical profession? The medical professional is expected to bring a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. The medical professionals are entitled to get protection so long as they perform their duties with reasonable skill and competence and in the interest of the patients. The interest and welfare of the patients have to be paramount for the medical professionals. The Honorable Apex Court in the matter titled as Kusum Sharma and others versus Batra Hospital and Medical Research Center in 2010 very rightly said that on scrutiny of the leading cases of medical negligence both in our country and other countries, especially UK, some basic principles emerge in dealing with the cases of medical negligence while deciding whether the medical professional is guilty of medical negligence. Following well-known principles must be kept in view. And these principles, they are enlightened. Negligence is the breach of duty exercised by omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent, reasonable man would not do. Negligence is an essential ingredient of the offense. The negligence to be established by the prosecution must be culpable and not the negligence merely based upon an error of judgment. If there is gross medical mistake, then the doctor will be liable for negligence committed by him. In such case, doctor would be liable to pay a huge compensation to the patient or his or her relatives. To protect oneself from such huge compensation to be paid, it is important and vital to obtain professional indemnity insurance. So what are the benefits of professional indemnity insurance? It is beneficial not only to the doctors or hospital, but also to patients and their dependents, because the insurance company takes care of the compensation. Retroactive benefit. This means that insured will be covered for any professional act or omission occurring during the period of insurance. We'll be talking about this retroactive benefit a little later. It would take care of amount of damages against third party. A scheme can also compensate on the principle of no fault liability to give some relief in the case of death or permanent disablement of the patient. This act in very few circumstances in our country, and I'll mentioning a case or two about that. The company will also pay the defense costs which have a direct relevance to the claim. The only limitation this policy has is that the amount of compensation is restricted by the limit of indemnity as mentioned in the policy. And that is why we have to choose it rightly. The insurance companies not only pay the compensation to other party, but also arrange for the legal help from advocates, because they sometimes join hand with the other party for monetary gains with an excuse that the insurance, not the doctor who is to pay the compensation. So this, to avoid that nexus, the insurance companies always prefer to come and join the defense. However, one must never forget that the security is only monetary. The person's reputation and goodwill is not insured. So all doctors should use their reasonable standard of care while treating and operating on their patients. So one should not think that, oh, insurance company is going to pay, so what, let them. But your definitely your goodwill, your reputation is at stake. And that's why even losing a case in consumer forum just like that is not good for your reputation. So what are the salient features of the professional indemnity insurance? First is the policy period. Period commencing from the effective date and hour as mentioned in the policy and terminating at the midnight on the expiry date as mentioned in the policy. Second is the period of insurance. The period of insurance means period commencing from the retroactive date, and this is a very important word, and terminating on the expiry date as mentioned in the policy. Now, this retroactive date always creates confusion among our mind. So let's be clear on that. A retroactive date is a date from which you have held professional indemnity cover. The retroactive date is prior to the date of inception of professional indemnity insurance. Basically, retroactive date helps you avail the cover for your past work and the mistakes that occurred in the past, which is before the policy's start date. This concept of backward cover can be for several months or years before the commencement of the policy. That means if you have drawn your first policy on 1st April 2010, say, and have continued without break till today, your retroactive date will be 1st April 2010. So whatever happened between then and now, you'll be covered. But the important proviso that one should not forget is that your policy should be continued right through this period without even a day's gap. And this is very important. And what happens is sometimes we change from one company to other. Then we have to make sure that the company we have changed to accepts the retroactive date as the date where we had started the policy from the previous company. And this is an important point that we must remember, while especially while changing from one company to other for whatever reason. Commission of Act. The Act, medical negligence by the doctor or hospital has to be committed during the period of insurance commencing from the retroactive date. Then runoff cover. Even after the doctor ceases to practice, there may still be a chance of claims against a doctor for work carried out before at the time of running the practice. Such claims are covered in the runoff cover, and this should ideally be mentioned in the contract, and we have to be careful about it. limit of indemnity, irrespective of the number of persons or entities named in the insurance policy or added by endorsement, the total liability of the insurance company for damages, inclusive of defense costs, shall not exceed the limit of indemnity as mentioned in the policy. And this again is very important to understand. We'll talk about it again later. The insurance company pays all costs, fees, and expenses incurred with their prior consent in the investigation, defense, or settlement of any claim made against the doctor or hospital, and the cost of representation at any inquest, inquiry, or other proceedings in respect of matters which have direct nexus to any claim made or which might be made against the insured. Such costs, fees, and expenses are called the defense costs. Now, this is again a technical term used, for indemnity insurance, the claim serige clauses, where the serige of losses and/or bodily injuries and/or deaths are attributable directly or indirectly to the same cause or error or commission relating to the discharge of the professional services. All such losses and/or bodily injuries and/or deaths claims shall be added together, and all such losses and or bodily injuries and or deaths shall be treated as one claim, and such claim shall be deemed to have been made when the first claim was made in writing. That means suppose a patient suffers some bodily injury and has to be reoperated. And so, again, that expense will also be covered. Then after that, maybe, patient suffers further, maybe as a second operation or maybe even the death. Then all that compensation for all in between things and the trauma that patient has suffered will be covered by your very first claim that you have put in, and you need not keep on claiming it again and again. It will all be including. So this claim serige clauses is very important for the professionals. Valid requirements. So what are and this is again very important. The doctor, there are requirements which you have to follow, and then only you are correct in having your indemnity insurance. So the doctor should be duly registered with his or her respective medical council. Hospital or medical establishment should be registered with a competent authority as per the local law and rules. Many times one forgets to register because there is usually sometimes 1 year or right now 3 years limit in our city for registration. So one should not forget to do that. Otherwise, having liability insurance will not have any meaning. In territories where there is no registration facility, then following minimal norms have to be complied with. That is like at least 10 inpatient facilities, fully equipped operation theater of its own, fully qualified nursing staff in its employment round the clock, unless indicated to the contrary, an additional premium paid. Well, we'll talk about it a little later. Fully qualified doctor should be in charge round the clock. The insured shall comply with registration formalities and when the official regulations or laws are enforced. Now, these certain items may differ from policy to policy, and sometimes you can insist if you are in a situation where you cannot follow all this, then sometimes by adding additional premium costs, you're allowed to fall into this particular sort of item. Then short period policy. Short period policies are not permitted generally. However, in case of cancellation of policy by the insured, short period scale rates are as provided for will be applicable. Then compromise or settle. Normal course, all claims for compensation have to be legally established in court of law. However, insurance can arrive at compromise or settlement in prima facie liability exist under the policy. This is what I was saying, two situations where there is a situation of what is called as res ipsa loquitur. That means somebody has left a sponge inside or something and it is bound to go against the doctor. Then, out of court settlement, discussing and with the patient can be arrived at by the company. Sometimes if the patient accepts no fault sort of benefit also, this can be negotiated sometimes with the help and permission of the court, or sometimes with arbitration proceedings also. So what are the exclusions. And this is something that, again, we need to know that the jurisdiction, of course, jurisdiction always is in Indian courts, but there are exclusions, and these are very important for us to know. Liability assumed under the agreement for, if for cosmetic surgery. Now, cosmetic surgery generally is not provided for indemnity, but there are special policies which can include that, again with addition of premium. Then liability arising of deliberate, willful, or intentional or non-compliance of such statutory provisions, loss of goodwill, libel, slander, false arrest, defamation, etc. Fines, penalties, punitive or exemplary damages, genetic injuries caused by X-ray treatment or diagnosis with radioactive substances, professional services rendered by the insured prior to retroactive date, war and warlike perils, nuclear fuel, ionizing radiations and radioactive contamination, and so on. These are generally in routine, are not covered by the indemnity insurances. As I said again, sometimes one can negotiate and get a different deal from the companies. The important thing is no insurance is allowed to cover a criminal act. So if actually a criminal act has happened, you're held criminally responsible, then no insurance company can come to your help. However, some insurance policies cover legal costs of defense in a criminal case, but are allowed to pay only if criminal act is not proved. Once criminal act is proved, you have to pay back to the company, even if they have spent for your defense in the due case. Then, again, it's important for us to know that, how do one decides the separate premium rates. So separate rates of insurance are applicable to doctors, medical establishments, and other professionals. Group discounts are available with insurance companies for group of doctors, and many of our associations have taken advantages of it. There is, the policy with IMA, with our Federation of Gynaecological and Obstetrics, POXI, and many other groups, have taken advantage, coming together, forming a group and negotiating with the companies. And that's a good way of doing things, because then you get a much better deal with the company, and also group discounts are available. And there are people to guide you as to, what kind of policy you should take and how you should negotiate. So additional premium is applicable in the case of doctors who want to cover unqualified staff working for them. This is very important, because in today's situations, all hospitals, especially small hospitals, have to have unqualified staff on their payroll, and sometimes if they create problem, that needs, and the premium added for this is not really much. It barely comes to 7.5%. So I think one should not be miserly, and most definitely accept and go for this additional premium. Whenever multiple specializations are involved, then the rate of insurance shall be of specialization which attracts higher rate of insurance. Of course, the insurance companies would always want that. So list of eligible establishment is laboratories and diagnostic centers, hospitals, maternity homes, mental homes, nursing and convalescence homes, homes for physically disabled, clinics, dispensing pharmacies, veterinary hospitals and clinics, and the like. So any health institute or health service can go for these kind of insurances. Exceptions for indemnity insurance. Well, now we already talked of some of them, but again, it's important to know that, as we said, criminal act is not covered. Then many, if the services are rendered under the influence of intoxicants or narcotics, if you're drunk and you have carried out a surgery, that is definitely not going to be covered. Then some policies don't cover the cosmetic treatments, and especially dental treatments under general anesthesia, unless they are happen only in the hospital. The use of course, this is again negotiable with the companies. The use of drugs for weight reduction are not covered. Plastic surgeries normally are not covered. Unfortunate things, the AIDS and related conditions are not covered. which, many of our medical insurance companies have, medical associations have now written to the ARDA, that the IRDA, the insurance main institute, that this should be covered, because as we are now giving many facilities to the HIV infected people, why not the insurance? That was an old thought, and now that should go away. So due to intentional non-compliance of statutory provisions, this is something important. Personal injuries such as falls, arrest, and so on, and genetic injuries. How to select the sum of insurance? That is again now becomes a crucial question. Indemnity insurance plans come with various limits. However, the policy can be customized based on following factors: the size and nature of the practice, the risk involved in that particular medical faculty. Naturally, it will be much different for a general practitioner or physician than for anesthetist and for obstetricians and so on. The estimated cost of defense and compensation for similar faculty should be taken into account, and size of clientele also is important, because if you have a large clientele, you're likely to have more problems too. The requirement of coverage ultimately depends on the risk exposure that the practice has. And here comes the, how do we choose the right limit then? And, this is where this, again, the second important, just like that retroactive date we discussed, this is something that we need to know about these insurance policies. And this limit is fixed per accident and policy period, which is called any one, accident limit or any 1 year limit respectively. So what does it mean? Sometimes you go, and ask for the insurance agent comes to you, says, no, your premium will be 15,000. You tell him, no, this is too much, I can't afford it, I want it to reduce. Then he goes back and happily tells you, oh, doctor, I've reduced this premium, now it is only 12,000 for you. And and also tells you, makes you very happy, saying that. But what he has done in between is he has changed, the little wording of your policy, and the ratio which was 1:1, that he has changed to 1:3 or 1:4. What does it mean? That AOI is the maximum limit of liability under the policy for any 1 year, and is expressed in ratio of related to 1. So if there is going to be only one case against you, then if you have a ratio of 1:4, and if you have a policy of 20 lakhs, you will get only 5 lakhs, compensation in that case. While if you have 1:1 ratio, then and if there is a compensation to be paid of 20 lakhs, and if you have the policy of 20 lakhs, all 20 lakhs you will get compensated. So it's important to remember that this AOY or the ratio 1:1 or 1:3 has to be carefully chosen. As a thumb rule, always choose the ratio of 1:1, because it's highly unlikely that you will be facing 2 or 3 cases in one year. So AOI limit, which is the maximum amount payable for each accident, should be fixed, taking into account the nature of activity of an insured, maximum number of people who could be affected, and maximum property damage that could occur in worst possible accident. Whenever doctors wish to cover unqualified staff working with them, the same may be allowed by collecting an additional premium of 7.5% of the indemnity premium. This again, as I said, is very important, and don't cringe on it. This can be sometimes really saving. Whenever multiple professional specializations are involved, then the rate applicable will be that of specialization, which attracts the higher rates. So let's see now, why this has all become so crucial to us as practitioners. And this is basically because of the changing judicial responses. The scenario has hugely changed regarding the compensation over the years. This was in 1996, Achyut Rao Haribhau Kondwa versus State of Maharashtra and others case. Actually the mop was left inside. So a clear-cut negligence, what we call res ipsa loquitur kind, and at the time of tubectomy. At that time, the compensation, this was of course in the civil code, and this was allowed was 36,000 rupees only. Then came in 1998. This was again a famous case, Spring Meadows Hospital versus Harjot Singh Ahluwalia. There was negligence in giving injection Lariago, which was given IV by the nurse and a resident doctor. The compensation of 12.5 lakhs plus 5 lakhs as interest was given by the National Forum. So it had gone up considerably. Then this was in 2009, Nizam's Institute of Medical versus the Prashant S. Dhanaka and others. Now, this decision was on cross-specialty practice. Cardiothoracic surgeon operated on neurological problem and not involving a neurosurgeon. Total amount of rupees 1 crore 5,000 plus interest of 6% was allowed in this particular case. So again, as you see, the compensation is going on increasing. And then the case of the famous case of Malay, Kumar, Ganguly and Sukumar Mukherjee. Here the court observed on one side, and this is very interesting to see, what the court had said, that it is sufficiently clear that a man of the medical field now residing at the United States with family after acquiring citizenship of that country had challenged the conduct and integrity of the three professors. In this connection, I deem it proper to quote a remark of Lord Denning in White House versus Jordan case in United Kingdom. Now, what Lord Denning had said, take heed of what has happened in United States. Medical malpractice cases there are very worrying, especially as they are tried by juries who have sympathy for the patient and none for the doctor who is insured. The damages are colossal. The doctors insure, but the premiums become very high, and these have to be passed on in fees to the patients. Experienced practitioners are known to have refused to treat patients for fear of being accused of negligence. Young men are even deterred from entering the profession because of the risk involved. In the interest of all, we must avoid such consequences in England. Not only must we avoid excessive damages, we must say firmly that in professional man, an error of judgment is not negligence. This is the kind of scenario which is emerging also in our country. People are getting worried about the compensations that they have to pay. But unfortunately, the Supreme Court, though mentioned this, did not quite agree with this statement, and the final compensation was quite big. So in another case, again interestingly, Supreme Court also noted that in case of Sarla Verma versus Delhi Transport Corporation, that the lack of uniformity and consistency in awarding compensation has been a matter of grave concern. If different tribunals calculate compensation differently on the same facts, the claimant, the litigant, the common man will be confused, perplexed, and bewildered. If there is a significant divergence among tribunals in determining the quantum of compensation on similar facts, it will lead to dissatisfaction and distrust in the system. The defendants in the most medical negligence cases assert that the method of determining compensation ought to be the multiplier method. The principal argument in favor of using such a method is uniformity and predictability. Doctors and hospitals will not be compelled to pay large sums of money to compensate for negligence. So this is what was discussed in this particular case. Then again, going further, the multiplier method was created to facilitate awarding compensation in relation to motor vehicle accidents to calculate no fault liability. Therefore, it accounts for the loss of income of the victim only. This sum is calculated by taking into account the multiplicand, that is the victim's salary minus the amount he spends on himself, and the multiplier, that is the total number of years that the victim would have earned in his salary. The multiplier is calculated by taking into account average life expectancy, the victim's age, the number of years that the victim will be unemployed, and any other factors concerning the victim's health. The usual formula utilized in this calculating compensation is 70 minus the age into annual income plus 30% for inflation minus 1/3 of the expenses. Defendants assert that this is the figure that will be adequately calculate the loss incurred, and therefore it should be utilized in cases of medical negligence. But the court, of course, even in this case, did not agree with this multiplier method. Court said that However, the compensation that is solely based on the income of the victim would imply that medical negligence causing death or injury to a wealthy individual is worth more than medical negligence that impacts an unemployed individual or a homemaker or a child or senior citizen. Quite rightly put, the Supreme Court has therefore refused to restrict compensation to the multiplier method in the case of medical negligence. Further, the Supreme Court has added other dimensions to the calculation of the compensation, such as the medical cost incurred by the victim during the litigation, cost of future medical expenses, compensation towards mental agony and physical pain, and compensation towards loss of consortium and cost of litigation. So in 2013, again in this famous Kunal Saha case, the compensation was awarded was, asked was huge, 77 crores plus the interest, which would have come to almost 200 crores. Fortunately, the Supreme Court did not agree to all that, but still the compensation which was allowed in this case was almost up to 13 crores in total. So again, in case of Krishna Kumar versus state of Tamil Nadu, there was delivery of a premature baby. Weight was 1250 grams. The baby was in Chennai. Baby had, this was a government hospital in Chennai. Baby had blindness due to retrorental hyperplasia due to 100% oxygen. Maybe not screened between 2 and 4 weeks as was mandatory at the outset. It may be noted that in such cases, this court has ruled out the computation of compensation according to the multiplier method. The court rightly warned against the straitjacket approach of using the multiplier method for calculating damages in medical negligence cases and quantification of complication. The principle avoiding the compensation that can be safely relied on is now called as restitutio in integrum. That means this principle has been recognized as the previous case, as I mentioned, and that's why now this is actually the principle that is going to be used in every case of compensation, and we have to be very much aware of that. This principle provides that a person entitled to damages should, as nearly as possible, get that sum of money which would put him in the same position as he would have been if he had not sustained the wrong. An application of this principle is that aggrieved person should get the sum of money which would put him in the same position if he had not sustained the wrong. It must necessarily result in compensating the aggrieved person for the financial loss suffered due to the event, the pain and suffering undergone, and the liability that he should have to incur due to the disability caused by the event. In this case, the compensation allowed was 1 crore 38 lakhs. So now finally, the practical points. This is all we should know. This was a lot of, detailed knowledge, but practical point that we have to remember are no doctor is totally safe from litigation in today's world. You may be a full-time employee, government servant, as you saw in the last case, employed in civil court, and also resident doctors. That is something that we have to remember. It is better to have indemnity insurance for your safety. In this last case, as I mentioned, the doctors were from government service and still they had to pay the huge compensation. So how do you decide limit of your safety? Remember in Kunal Saha's case, the compensation asked was 77 crores. Unfortunately, there is no upper limit for the compensation to be asked. So one has to decide, and since fortunately one thing is that still in our country, the insurance premium are comparatively cheap compared to United States and other countries. And so for a good amount of insurance, nowadays, anything between 50 lakhs to 1 crore, depending on your practice, would be the minimum amount that we have to think of at insurance. We always tend to forget that the interest part, which unfortunately entirely at the judge's discretion, how much percent interest is to be put. In one of the cases, the initial compensation allowed was only rupees 3,200. The National Forum increased that to 5 lakhs, which was also allowed by the Supreme Court. And by the time the result came, the amount had become 15 lakhs due to all the compensation and the interest that had to be paid. So, well, we also have to nowadays remember about compassionate compensation. This is also tricky. Many times the courts say, oh, well, there is no clear-cut negligence, but the patient has suffered and anyway the insurance company is going to pay. So, doctor, let's allow the insurance company to pay some amount. But here the case goes against the doctors, and as I said in the beginning, your reputation does suffer. Some of the mistakes that we should be aware of: if you have insurance in your name, that doesn't mean that your clinic is also automatically covered. For example, a radiologist had a good indemnity insurance. He carried out MRI under GA on a patient. The patient died due to anesthesia complication. The anesthetist and the imaging center were sued in the court. Even though the individual radiologist, who is the owner of the center, had indemnity insurance in his name, the insurance company refused to cover, as not him but the center was held liable. So there should be two insurances always, one for the individual and second for the establishment. In individual insurance, make sure that all the places where you go and operate are specifically mentioned in the insurance contract, and also add that any more place where I will be requested to operate. Better still, you can say anywhere in India I am called to operate, and that will cover you substantially. While filling the form for the hospital establishment, two precautions: make sure that the name and address of the establishment is properly mentioned. Ask for cover for your untrained health assistants working in the hospital staff. There was a case where, when the patient was being shifted by obviously the untrained staff, the patient fell down and suffered a fracture, and for that the case was filed. Fortunately, here the establishment had a policy which covered the untrained health assistants, and the insurance company paid for it. So next precaution: read the contract carefully, word by word. Why? Because in USA, the cases are decided a little differently. In this particular case, the court said that because the recovery of this specifically listed exception, which was temporomandibular joint syndrome, which was actually excluded. But court added that, reasoning that contract language must be plain and conspicuous and must not disappoint the reasonable expectations of the purchaser. To that extent, some court in USA have gone further, and they're willing to take this duty to protect the insured even further, and as a result adopted wayfaring full doctrine. This doctrine requires the insurer to use language that is plain and clear enough that average person, even if he or she is a fool, could interpret it correctly. I hope that this is accepted in our country soon. Unfortunately, in our country, the contracts interpreted mostly are exactly by the words mentioned, so we need to be more careful. In one case, the insurance policy mentioned the name as Ram Kinkar Hospital instead of Shri Ram Kinkar Charitable Medical Institute, which remained uncorrected, and hence the payment was refused. So in conclusion, professional indemnity insurance is a tool which not only meets the claim of compensation awarded against the doctor or hospital, but also gives a sense of mental security. And that is very important, that even if some negligence is proved, the insurance company will take care of the compensation part of it. The professional indemnity insurance covers all sums which the insured professional becomes legally liable to pay as damages to the third party in respect of any error or omission on his part committed whilst rendering the professional service. In present scenario, then you will all agree that in our country, especially after the amendments in CPA now recently in 2018, the compensations having to be paid by the doctors are going to increase substantially. Hence, it is only wise to have a good indemnity insurance cover for mental and economic stability in the future. So with that, let me hope that you do not need this indemnity insurance, but still do always have that indemnity insurance, which will at least give you mental security, if not in certain events, really protect you in a great way. Thank you very much for your kind listening.
Thank you so much, sir, for throwing light on such an essential topic. We have with us Advocate Dr. Milind Salunke, sir, who will be asking you the question for the day.
Sure.
Sir, good evening, sir. I have received so many questions from the student, but due to the scarcity of time, I think
Milind, I will also need your help in answering some of these.
Certainly, I'll be there.
You're also an expert, medical legal expert.
Yeah, it's my pleasure, sir. It's my pleasure. And I'm your student, sir. You are my mentor. The question is, does indemnity policy take care of the compensation awarded by criminal code under section 357?
No, that we already said, no, it doesn't. If it's a criminal act which is proved in the court, no compensation the policy can cover it. The criminal.
They are asking regarding compensation. They are not asking regarding the punishment.
No, even the compensation is not allowed to be paid by in a criminal case which is proved. If the criminal case is not not proved, then only the defense expenses are allowed.
Nowadays, due to judicial activism, nowadays, if you see the majority of the judgment pronounced by the criminal court under section 304A, they are utilizing power conferred under section 357, along with punishment after the concluding that the accused is guilty of the medical negligence. Apart from the conviction, the quantum of the punishment, they would pronounce the compensation under 357 to be paid to beneficiaries or to the victim, so as to say. So whether that would be covered or not, that was the question.
In present situation, it will not be. I think this will have to take up with the IRT and insurance company, then maybe we'll have to work at that to develop certain kind of policies. But as now our law stands, this cannot be covered.
Thank you, sir. Once again, it was indeed a great pleasure having you join the board this day, on this day. And we hope we can see you sometime really soon, hopefully in person as well. Thank you, sir.
That's right. And next time, let's meet as usual in the wonderful auditorium that we are missing all that.
Right, sir. Thank you, sir. Thank you once again.
Sure.
With this, we come to the end of day 1 of SYMHEALTH, hoping that each and every one of you takes back a cherished experience. Please join in tomorrow's session as per the given schedule, and joining in 15 minutes before the commencement of the first session at around 10 o'clock would be highly appreciated. As always, be positive and test negative. Take care. Thank you once again and see you tomorrow.